Alex here with part 173 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into, I think we left off with my ex's attorney's opposition to our motion for order to show cause, if I remember correctly. And now we go into our reply to that opposition to motion. And I can't quite recall the mindset at this time. I really feel like this order to show cause is really not one of the ones that makes a big sort of splash in this case. I know that it's going to get brought up at the upcoming hearing, which, by the way, guys, is the next video. So definitely be ready for that next video. Part 174 will be premiered, as with all the other hearing videos, and it'll probably be scheduled, I would imagine, Tuesday. I think I'm going to release this video tomorrow, and then we'll premiere that hearing video on Tuesday. That's what I think I'm going to do. In any event, because I can't really recall my mindset at the time, it really leads us to just having to go straight into what my attorney has filed. Here we have the reply to opposition to motion for order to show cause filed by my attorney. In the standard introductory paragraph, she indicates that she is my counsel of record and that she's filing this reply on my behalf. Let's hope that most of this isn't copy-paste. It may end up being that sort of situation. Allegations related to the $50 payments. So, let's see here. My ex has made only two $50 payments as ordered by the court. She alleges she has made 5 payments. Okay, I think I talked about this before. I'm conceding as stated that to date I have received only 2 $50 payments. And guys, this is going to sound nuts that she issued all those money orders and didn't send them to me, but that's exactly what she did. She issued those money orders and she destroyed them. I mean, for a second we thought she may have cashed them herself because we actually did look into it. My attorney looked into it, but she only looked into it maybe, I can't remember if it was before the hearing or after, but in any event, I am very curious to know now if I can go and check that out. Maybe I'll do that. Maybe I can contact whoever it was that issued the money orders, because for all we know, she may have cashed her own money orders 6, 7, 8, 9 months, maybe years after the fact. I'm very curious about that. Now that I'm doing this channel, it's pretty relevant. I'm going to put that down on my to-do list, see if I can look into that. In any event, the whole section here just goes into me refuting the fact that I didn't get these money orders. And I also, okay, so it's a MoneyGram, so this is the company for me to contact. I also, let's see here. I mean, it's pretty detailed, but most of this stuff should be really discussed in an evidentiary hearing. It's kind of like I'm trying to argue in the paperwork, which I guess family court judges like, because they like to rule on the paperwork and not do evidentiary hearings, but this isn't really the way to go. This is the kind of stuff that would come out in testimony and cross-examination. Anyway, it's a long, convoluted explanation as to why she's wrong. And I'm also, this is an interesting citation here. I think it's McCormick v. Sixt, which places the burden of proof on my ex to show that she's not in contempt. So what I'm trying to say here is that the burden of proof is on her to show that she actually sent these money orders. Which is good because it's not really fair for her to put that burden on me. Let's see. And then there's also this is a good case here, which it's Las Vegas Metro versus Police Department. Or sorry, it's Las Vegas Metro Police Department versus Courageous Insurance Company. This case is really, I've used this a few times before, and the reason I like it is because they concede in this case that it is prejudicial to force a litigant, to prove a negative. it's very difficult and unfair to show the court that something that didn't occur didn't occur. The burden should really be on the other person to show that the thing did occur. And they talk about that in this case. It's not in dispute that my ex purchased the money orders as she's provided receipts showing she had, and this just goes into what we said before. Long, convoluted explanation as to why she didn't send these to us and she should still be held in contempt. Reply to the allegations related. By the way, guys, I'm pretty sure that somewhere in that giant section that I asked the court to from now on have her pay in some way that's trackable. I'm trying to remember, maybe it was through check or I don't really remember now. In any event, there's no reason to talk about it too much here because it's going to come up at the hearing. And, I know that the district attorney's office starts garnishing her wages anyway. That's only going to handle the child support, though. The arrearages, if I remember correctly, those were seized in an income tax refund, or maybe at the very last minute she just paid a giant lump sum. One of the two things occurred, and I've to this day not really known for sure which one it was. But in any event, all that stuff gets paid off. It just takes years and years for it to happen. Let's see here. Duty to keep. What is this? Allegations related to child support arrears. This is kind of a no-brainer. My ex is playing dumb. She's saying that she thought that child support enforcement would take all the child support from her. I think most parents know, first of all, that they take a certain percentage, but it may or may not be consistent with the court's order, and they're still going to owe a balance if it's less than the court's order. And then there's also the whole issue of when the money starts getting taken, the money starts getting taken. But for all that time before, when the money isn't being taken, you still have to pay that. That's not just like free money for you. I can kind of understand maybe that some people would be confused as to the former. But when it comes to the latter, I don't think many people would think that, hey, if it takes 6 months for child support enforcement to start taking my checks, and that's just 6 months of no child support for me. I can't imagine who would think that that's how it works. But that's what she's saying here. And by the way, guys, I don't think that child support enforcement starts seizing her money until, I think right now in this case, we're in 2015. I don't think they start until 2016. So it does take quite a while for them to start that up. So this is all this explanation with regard to the child support arrears. Here we have the unrecovered medical expenses. This is probably, let's take a look here. So my ex is saying that she didn't participate in this process, therefore she shouldn't have to pay, which is not what the statute says. But in any event, let's see here. Undersigned counsel sent my ex an email discussing the appointment. My ex responded to the email, so she knew about the appointment. Guys, Exhibit 2, Exhibit 3, Exhibit 4, we're going to go through all these exhibits and talk about how she knew about the appointment. She's going to have to pay that money too. The ultimate payment does not preclude contempt. She's repeatedly demonstrated compliance to court orders only when cornered. It's a waste of judicial resources to continue this pattern. It's like the judges, again, guys, I've said this a million times. The judges complain about having too much work, but because of their own conduct, they end up creating all this extra work. They do this to themselves. My ex is only paying when a motion has her back to the wall. So what does that tell me? That tells me that I'm not going to get paid until I file things. What does that do for the court? Now the court has to deal with all these filings. There was somebody who posted, I think it was Made with Diamonds, I'm pretty sure it was. This user posted in the comments below how ridiculous all this was, over $50. And in reality, I think it's over more than that because of the child support and all that. But it's still ridiculous. The court said to pay it, and she's not paying it. And so all this motion practice, all these attorney fees are going into all this extra work because the court won't punish her. And guess what's going to happen after all this nonsense? She doesn't get punished. I don't get paid. And years and years and years later, she finally ends up paying through the use of legal force by the district attorney's office. And they also file a motion for order to show cause, by the way. They try and jail her too, but they can't find her at that point in time. They can't even serve her. She's completely vanished at that point in time. But all of this extra work is the court's own doing. So if you ever see judges complain, oh, we have so much work, well, you kind of create your own extra work for yourselves when you do this kind of stuff. That's what's going on in these high conflict cases. They don't crack down, so more filings get filed. And I think some people say, yeah, well, things are going to get filed anyway, no matter what. Well, that's not true, because in this case, as the pressure continues to get applied to my ex, because she's going to lose her legal custody, she's going to lose all of her other rights, and then she's going to get TPR'd. Well, the filing stopped. So maybe, taking a stern approach and applying the law correctly isn't necessarily the recipe for more litigation. I know a lot of judges and attorneys think that that's the case, but it's not true, at least not in my case. Applying the law correctly and applying the law strictly and taking an assertive, firm approach in a case ended up ending the filings, which is exactly what they probably wanted all along. And it wouldn't have taken 6 to 8 years if they would have figured this out from the beginning. Moving into, if you want to learn more about why I think this happens, please watch my video on the topic high conflict incompetence. And you can also watch my video on the topic end of filings is not end of abuse. Both of those videos are pretty relevant on this. Reply to the payment of outstanding funds. I'm not disputing the reasonableness of the fees. I am disputing the award itself. An appeal for attorney fees on a post-judgment order is appealable, blah, blah, blah. We all know that this is true. I don't know if the judge and the attorney thinks it's true, but it doesn't matter because, who does think it's true? The Court of Appeals. And this is going to go in my favor. And my this judge's award of attorney fees will be overturned on appeal. Going into conclusion, it's a pretty standard conclusion, just reiterating everything said before. We have the certificate of service under Rule 5 indicating this document was mailed to my ex's attorney. Actually, no. Personal delivery, which you can do if you want to under Rule 5. Apparently, this my attorney had this delivered to them. And then we have exhibit list here. 4 different exhibits. Hopefully, these are new. Exhibit 1. Okay, flight reservation. My ex is saying that she can't set up the boarding pass because he's a minor. I have to take him to Southwest ticket counter. That sounds weird. If you can't see this info, there was a lot more that she had to fill out. Okay. Also, the cell phone thing, guys. I talk about pretty thoroughly in the video boundaries. I'm not sure that I've talked about it much here. It's going to come up at the hearing. You're going to hear a lot more on this at the hearing. If you want to know more about it prior to the hearing video, please watch the video boundaries. This is all the flight stuff, guys. Here's my ex saying that our son will be getting there at 18:55, which is military time for 6:55 p.m. Have to be there by 1800 to fill out the stuff and go to the gate. Okay. On a small note, in the future, please put my wife as an alternate pickup just in case. What? She wants something about, okay, anyway, this is just standard parenting stuff, guys. Communication with the teacher, one of those times where short notice isn't going to work out, as I have plans with him. Okay, so this must be over like the school visit that she wants to have with him. Look, and here it is, I'm saying this is the 3rd time this has happened. Existing court orders and the notice of compliance requires 30-day notice in advance. Okay, and it's like, it doesn't matter. When I send this to her, it gives her a signal of, okay, I need to violate this. Since he is upset about this particular issue, I need to keep doing this. It's like, it's almost like reverse psychology, but not in the way that it was intended to work. Going into exhibit 2, we have my attorney communicating with my ex about a dentist appointment. I still think that this is so ridiculous that attorneys have to do this kind of stuff. But if the judges aren't going to do anything about it, you kind of just end up having to do it. Highly inappropriate. And I wish the judges would all get on the same page. If a parent can't do this stuff, they should not have parental rights. The Supreme Court has stated this. I don't know why the judges don't do what the Supreme Court tells them to do. The Supreme Court has stated legal custody rights come with legal custody obligations. If you don't satisfy your legal custody obligations, you don't get your legal custody rights. Attorneys, teachers, all these other people should not be having to do this for a parent. If a parent can't exercise their legal custody obligations, they do not get to have their legal custody rights. In Nevada, it's Rivero v. Rivero 2009. The Supreme Court said so, and if more judges did this, less children would suffer. I don't know what else to say, guys. This is not appropriate. You can't, it's so obvious. Like, I really can't imagine who would listen to me at this point and say, I don't agree, Alex. I really do think that lawyers should get involved in the parenting of the children. Like, my mind is blown at this ridiculous notion, but this is what happens in these cases because the judges don't do their jobs, and so the attorneys end up having to do this kind of stuff. It's really messed up. Let's go into next section here, Exhibit 3. My ex is now communicating with my attorney. 35 minutes pass when our child is supposed to be dropped off. She's been sitting there since 10. What is going on here? My ex is saying that she just read something. She wasn't checking her email while on vacation. She's supposed to get a text. Urgent medical information. Is it urgent though? Wasn't that like a long, like a normal amount of time for that? I don't know. Um, oh, this is the paste. She's saying she doesn't even know about the paste. I wish I could remember the name of that stuff. You know what? That comes up at the hearing anyway, so we'll just talk about that when we get to the hearing video. But that there's like a special type of toothpaste that they gave for him following all that dental care they had to go through. We got Exhibit 4 here. And then this is a communication from my attorney to my ex's attorney. She's saying that she got a bunch of emails from my ex on Sunday, January 4th with regards to a drop-off. It was my understanding that since he had just a 10-day visit with her, that her visitation did not resume until next week. The matter was resolved. What is going on here? There was no need to, as the school did not resume from winter break until Thursday, at which time our son will be with me. So, guys, if I don't remember this, it must have been a non-starter. There's a chance that it might get talked about at the court hearing, maybe, but I doubt it. A lot of this stuff is just fluff. You know, my ex is hurling allegations and accusations, and it's just not going anywhere. If I remember something vividly, I can give you more details behind it, but I can't remember this dispute. And then my ex is communicating with my ex's attorney again about more procedures, more dental procedures and stuff. It looks like this is a request for submission. Why is this attached to this? Oh, this should be a separate document, guys. I'm going to go ahead and separate this out so that it appears as a separate document, and down in the description below, it should be, it shouldn't be, blobbed in with this document. And then, of course, if you have any questions about the request for submission, please watch my video on the topic, request for submission. And last but not least, on the affirmation, this is required to show that there's no social security number in this specific document, which is just a request for submission in this case. And that's just, I don't know if I actually have a video on the affirmation, but we've seen so many of these by now. Certificate of service under Rule 5 indicating this document, which is just a request for submission, was mailed to my ex's attorney. That's it. Going into the aftermath, I filed 2 documents, but they were free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. My attorney is helping me for free, so I incurred $0 in attorney fees. My ex's attorney, it's a pretty lengthy reply and request for submission. Usually something like this, most of the time in my docket series, I just say 15 minutes, but for something this detailed, especially with all those attachments, it's going to create a lot of, I guess you could say, talking points between my ex's attorney and her. So I'm sure that the attorney would have had to communicate with her and get briefed on that before the hearing video. So I think an hour under the circumstances is reasonable, which at the rate of $250 an hour will come to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.